Thank you, Mr. President. Mr. President, distinguished members of the Court, it is an honor to appear before you today on behalf of the Kingdom of the Netherlands to participate in this hearing on the request for an advisory opinion on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. Let me express my sincere appreciation for this opportunity to speak early in this hearing, as the other participants have not had an opportunity to comment on our views in writing. The Kingdom would like to begin by underlining that, for the purposes of the present advisory proceedings, it leaves it to the discretion of the Court to satisfy itself that it has advisory jurisdiction and that it may exercise this jurisdiction with respect to the present request, in accordance with Article 65, paragraph 1 of the Statute of the Court and Article 102 of the Rules of Court. The Kingdom would like to emphasize that it considers that, and I quote from the advisory opinion on the construction of a wall, the object of the request before the Court is to obtain from the Court an opinion which the General Assembly deems of assistance to it for the proper exercise of its functions, unquote. Therefore, the request should be regarded in a much broader frame of reference than a bilateral dispute. And it is with such broader frame of reference in mind that the Kingdom seeks to assist the Court in answering the questions contained in the request through the identification of the applicable international law and the presentation of the legal opinion of the Kingdom on the status and interpretation of that law. Mr. President, distinguished members of the Court, the Kingdom would now like to turn to the questions posed in the present request for an advisory opinion. Mr. President, according to the Kingdom, the right of self-determination of peoples is a permanent, continuing, universal, and inalienable right with a peremptory character. The principle of self-determination of peoples is enshrined in Articles 1 and 55 of the United Nations Charter. It is also contained in several resolutions of the General Assembly with historical importance, such as Resolution 1514, which states that, and I quote, all peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue the economic, social, and cultural development, unquote. The right of self-determination has been reaffirmed by the General Assembly in Resolution 2625, pursuant to which every state has the duty to refrain from any forcible action which deprives peoples referred to in that resolution of their right to self-determination. In addition, this right is enshrined in Article 1, common to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. The Court has acknowledged self-determination as a right of peoples in the Namibia Advisory Opinion, the Western Sahara Advisory Opinion, the East Timor case, the Advisory Opinion on the construction of a wall, and the Advisory Opinion on the separation of the Chagos Archipelago. In the East Timor case, the Court observed that the right of peoples to self-determination is a right erga omnes. The status of the right of self-determination as a right under customary international law is thus beyond reproach. According to the Kingdom, the right of self-determination is applicable in the colonial and in the post-colonial context. The right is, however, equally applicable to peoples under foreign or alien occupation, as confirmed by the General Assembly on several occasions, such as in Resolution 51/84 and its Millennium Declaration. It appears that the right of self-determination is a truly universal and continuing right. It applies to peoples under colonial domination, peoples residing in occupied territory, and peoples living in independent states. As a result, a state that occupies territory is under an obligation to respect and promote the right of self-determination of peoples residing in that territory. The obligation to respect and promote the right of self-determination means that, on the one hand, the occupying state shall refrain from measures that impede the exercise of the right of self-determination of the people concerned during the occupation, and, on the other hand, that the occupying state shall take measures aimed at creating the conditions under which the people concerned is able to freely and genuinely express its will in regard of its future political status. As the Kingdom has observed earlier, under international law, a distinction must be made between situations in which the right of self-determination is exercised in a manner that preserves international boundaries, which can be referred to as internal self-determination, or in a manner that involves a change of international boundaries, often referred to as external self-determination. In the context of colonial domination or foreign occupation, the right of self-determination can be realized through independence, association, or integration. A prolonged occupation obstructs the implementation of the right of external self-determination of a people residing in the occupied territory concerned. In regard of, amongst others, peoples under foreign or alien occupation, the General Assembly reaffirmed in Resolution 45/130, and I quote, "The legitimacy of the struggle of peoples for independence, territorial integrity, national unity, and liberation from colonial domination, apartheid, and foreign occupation by all available means, including armed struggle." Unquote. If a struggle by a people for the implementation of its right of self-determination in the context of colonial domination or foreign occupation is accompanied by the use of armed force by such people, this use of armed force must be in accordance with international law. Mr. President, I will now address the law regulating the use of force, in particular the UN Charter and its prohibition on the use of force by states, contained in Article 2, Paragraph 4. According to the Kingdom, the prohibition of the use of force is a rule of jus cogens that applies erga omnes. Indeed, in the advisory opinion on the construction of a wall, the Court confirmed that the principles as to the use of force incorporated in the UN Charter reflect customary international law. In 1966, the International Law Commission noted that the law of the UN Charter concerning the prohibition of the use of force in itself constitutes a conspicuous example of a rule of international law having the character of jus cogens. Consequently, the International Law Commission included the prohibition of aggression in its list of rules of jus cogens. One of the established exceptions to the prohibition on the use of armed force is that of the inherent right of individual or collective self-defense, if an armed attack occurs against a state, as codified in Article 51 of the UN Charter. The occupation of foreign territory can be legitimate in the exercise of the right of self-defense in response to an armed attack, provided that the use of force is exercised in accordance with the conditions attached to this right. The substantive customary conditions are necessity and proportionality, in addition to the procedural condition contained in Article 51 to notify the Security Council of the actions taken in self-defense. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court noted, inter alia, that proportionality and necessity are inherent in the very concept of self-defense. So if the placement of a territory under the control of an armed force is the result of a military operation in the exercise of the right of self-defense, necessity requires an assessment of whether the occupation and the continuation thereof is necessary to repel the armed attack or that alternative courses of action are available. This inherently supposes also a temporal element of immediacy. If the right of self-defense is not exercised relatively promptly, it may imply that the exercise of the right of self-defense was unnecessary. Furthermore, with regard to proportionality, the question is whether the occupation and the continuation thereof is proportionate in relation to the armed attack, both in qualitative and quantitative terms. If that is not the case, the occupation may be considered to violate the prohibition of the use of force. These conditions to the exercise of the right of self-defense apply as long as there is an occurring or imminent armed attack. Also, in exercising the right of self-defense, the occupying state must fully respect international law, in particular human rights and international humanitarian law. Mr. President, it is the view of the Kingdom that the right of self-defense can also be invoked in response to an armed attack by a non-state actor. This is illustrated, for example, by the Security Council's resolutions adopted after 9/11, in which the Security Council reconfirmed the right to self-defense in response to those attacks. An occupation which fulfills the requirements of the right of self-defense may be considered as lawful under jus ad bellum. An occupation which does not fulfill or no longer fulfills these requirements may lose its legal basis and hence violate the jus cogens prohibition of the use of force. Finally, the Kingdom underscores that occupation is an inherently temporary use of force, because if it were to be permanent, it would qualify as annexation. As the Security Council emphasized in 1967, in its unanimously adopted Resolution 242, the acquisition of territory by war is inadmissible. The Court recognized the customary status of the illegality of territorial acquisition resulting from the threat or use of force in the advisory opinion on the construction of a wall. Mr. President, the Kingdom now turns to international humanitarian law, or jus in bello, which regulates situations of armed conflict, including occupation. According to the Court, and I quote, "A great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity," end of quote, "that they are," and I quote, "to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law," end quote. In the Court's view, these rules incorporate obligations which are essentially of an erga omnes character. The Kingdom considers these principles, furthermore, to be a peremptory norm of general international law, and would like to refer in this respect to the conclusion of the International Law Commission to include the basic rules of international humanitarian law in its list of rules of jus cogens. The Kingdom submits that, while international humanitarian law is applicable in situations of occupation, international humanitarian law does not contain rules for determining whether an occupation is lawful or unlawful as such, even if breaches of the rules are serious in nature. Rather, irrespective of its legality, international humanitarian law regulates situations of occupation once such a situation has arisen in fact. As noted by the court, and I quote, "Under customary international law, territory is considered occupied when it is actually placed under the authority of the hostile army, and the occupation extends only to the territory where such authority has been established and can be exercised," unquote, as reflected in Article 42 of the Hague Regulations of 1907. As stated before, inherent in occupation is its temporary nature. Under the Hague Regulations, the occupying power shall be regarded only as administrator or usufructuary. After the Second World War, the Fourth Geneva Convention further developed the law of occupation by significantly enhancing the protection of civilians in situations of occupation. As noted by the court, the intention of the drafters of the Fourth Geneva Convention was to protect civilians who find themselves, in whatever way, in the hands of the occupying power. Furthermore, the drafters of the Fourth Geneva Convention sought to guarantee the protection of civilians in time of war, regardless of the status of the occupied territories. Once an occupation has factually occurred, the occupying power is obliged to act in accordance with the law of occupation. The occupying power has to respect and protect the civilians in the occupied territory who are regarded as protected persons. Protected persons are, inter alia, entitled in all circumstances to respect for their persons and shall at all times be treated humanely. Private property is to be respected. At the same time, such measures of control and security may be taken by the occupying power in regard to protected persons as may be necessary as a result of the war. As noted before, no sovereignty can be established over occupied territory, and occupied territory may not be annexed. In this regard, an important provision under the law of occupation is that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Under international criminal law, such transfers, directly or indirectly, by the occupying power, constitute a war crime, as reflected in the Rome Statute of the International Criminal Court. It is also prohibited to deport protected persons from the occupied territory. The Kingdom underscores that all high contracting parties to the Geneva Conventions are under an obligation to ensure respect for the Geneva Conventions with reference to Article 1 common to those conventions. As noted by the Court, and I quote, "Every state party to that convention, whether or not it is a party to a specific conflict, is under an obligation to ensure that the requirements of the instruments in question are complied with," unquote. Mr. President, in relation to international human rights law, the Kingdom would first note that this body of law continues to be applicable during situations of armed conflict, including occupation. The Court has come to this conclusion in its advisory opinions on legality of the threat or use of nuclear weapons and construction of a wall. It added, in the case concerning armed activities on the territory of the Congo, that, and I quote, "International human rights instruments are applicable in respect of acts done by a state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories," end of quote. The International Law Commission has equally concluded that human rights treaties continue to apply during armed conflict in its 2011 draft articles on the effects of armed conflicts on treaties. It follows that an occupying power, for the purposes of international humanitarian law, is bound to respect, protect, and fulfill the human rights of all those within the occupied territory. The obligations owed by states under rules of universally applicable customary international human rights law are of an erga omnes character. The court has confirmed this in the Barcelona traction case, considering that erga omnes obligations, and I quote, derive, for example, in contemporary international law from the principles and rules concerning the basic rights of the human person, unquote. According to the court, this includes the prohibitions of genocide, slavery, and racial discrimination, as well as the prohibition of torture. Certain rules of international human rights law can moreover be characterized as peremptory norms of international law. According to the International Law Commission, this includes the prohibition of genocide, the prohibition of torture, the prohibition of slavery, and the prohibition of racial discrimination and apartheid, as well as the right of self-determination. Mr. President, both questions before the court concern the legal consequences of ongoing violations of rules of international law. Several of these rules are, as indicated, peremptory norms of general international law. As we have stated before, all such peremptory norms are applicable erga omnes. I will now address the additional legal consequences for all states and international organizations in the event of a serious breach of such a peremptory norm. It being noted that these consequences are additional to the regular obligations arising from the commission of an internationally wrongful act. The rules on the legal consequences for states when a serious breach of a peremptory norm occurs are reflected in Articles 40, 41 and 48 of the Articles on the Responsibility of States for Internationally Wrongful Acts. The relevant provisions for states and international organizations may be found in Articles 41, 42 and 49 of the draft Articles on Responsibility of International Organizations. According to the Kingdom, these provisions reflect customary international law. These legal consequences may be divided in two categories: substantive consequences and procedural consequences. I will only address the Articles on State Responsibility in my statement. However, it is equally applicable to the draft Articles on the Responsibility of International Organizations. Article 40 of the Articles on State Responsibility defines a serious breach as a gross or systematic failure by the responsible state to fulfill its obligation under a peremptory norm. Article 41 stipulates the particular substantive consequences of such a breach, not only for the responsible state, but for the international community as a whole, including that state. In sum, states shall cooperate to bring the serious breach to an end, shall not recognize as lawful a situation created by such breach, and shall not render aid or assistance in maintaining the situation. The Court has confirmed the binding nature of the rules reflected in Article 41 in jurisdictional immunities. The Court has on multiple occasions pronounced on the legal consequences of serious breaches of norms affecting the international community as a whole. In Barcelona Traction, the Court established that obligations owed towards the international community as a whole are the concern of all states, and that, and I quote, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes, end of quote. The Court further confirmed these obligations in its advisory opinions on Namibia, the construction of a wall, and the separation of the Chagos archipelago. Thus, the jurisprudence of the Court supports the obligations reflected in Article 41 of the Articles on State Responsibility. The Court has also identified the obligation of non-recognition and the prohibition to render aid and assistance, and the obligation to cooperate to bring the consequences of the serious breach of a peremptory norm to an end. As to the specific implementation of these rules, the Kingdom observes the following. First, the obligation to cooperate to bring to an end the consequences of the serious breach of a peremptory norm will, in most cases, and particularly in cases concerning self-determination and decolonization, be implemented most effectively through the United Nations. However, should cooperation in the context of the United Nations fail to materialize, or should the United Nations be unable to take appropriate action, states are not relieved from their obligation to cooperate to bring the consequences of the breach to an end. In that case, they are obliged to seek cooperation through regional or bilateral fora. Second, the obligation not to recognize as lawful the situation brought about through the serious breach of a peremptory norm must take into account the exceptions to that rule as formulated by the court in the Namibia advisory opinion. Third, the rendering of unlawful aid and assistance contrary to the prohibition thereto does not give rise to international responsibility of the aiding or assisting state for the underlying situation or internationally wrongful act, but only for its unlawful aid or assistance. Fourth, the obligation not to render aid or assistance includes an obligation not to undermine measures, including sanctions, taken by other states in their endeavor to bring to an end the serious breach of a peremptory norm. In particular, when the state undermining those measures does so knowing that its conduct contributes to the maintenance of the unlawful situation. Finally, it is our view that a serious breach of a peremptory norm entitles states, other than the injured state, to take a countermeasure against the responsible state as a legal consequence of that breach. Such resort to countermeasures by a non-injured state must be in accordance with the customary rules on countermeasures, including the conditions of proportionality and reversibility. As a final observation, it may be recalled that the Kingdom considers that all peremptory norms are applicable erga omnes. Therefore, the procedural legal consequence of a serious breach thereof is that all states and international organizations have legal standing to invoke responsibility for such a breach. They may claim cessation of continuing internationally wrongful acts, assurances and guarantees of non-repetition, and performance of the obligation of reparation. A claim concerning reparation is restricted in the sense that it must be in the interest of the injured state or international organization or of the beneficiaries of the obligation breached. And such beneficiaries may include individuals and peoples. Mr. President, this brings me to the end of my statement. We sincerely hope that your advice will contribute to achieving peace in the Middle East. Thank you, Mr. President.
I thank the delegation of the Netherlands for its presentation. I invite the next participating delegation, Bangladesh, to address the court. Let me call upon His Excellency Mr. Riyaz Hamidullah to take the floor.
Mr. President, members of the court, it's my distinct honor and privilege to address the principal judicial organ of the United Nations on behalf of the People's Republic of Bangladesh and participate in these advisory proceedings on the legal consequences arising from the policies and practice of Israel in the occupied Palestinian territory, including East Jerusalem. Bangladesh fought for 23 long years to gain her independence and finally achieved it through a bloody war in 1971, during which 3 million people had to sacrifice their lives. In the early days of independent Bangladesh, in 1972, our father of the nation, Bangabandhu Sheikh Mujibur Rahman, said, I quote, "The world is divided in two parts, oppressors and oppressed, and I am with the oppressed," unquote. As Bangladesh pursued her own self-determination, our constitution mandated us to support oppressed peoples worldwide who are fighting imperialism, colonialism, or racism. This duty is outlined in Article 25C of our Constitution. In accordance with this duty, Bangladesh is participating in these advisory proceedings to contribute to the realization of the right of the Palestinian people to self-determination. We aim to achieve this by providing this court with our perspectives on the questions asked by the UN General Assembly in the current request for an advisory opinion. Bangladesh has long reiterated the call to end Israel's occupation of Palestine and to achieve a lasting and permanent solution which entails the establishment of a sovereign and independent Palestinian state along the pre-1967 borders, with East Jerusalem as its capital. We firmly believe that the court must heed the long overdue call to holistically examine Israel's occupation and render an opinion on the legal status of the occupation as a whole. As we heard in this very hall just last month, Gaza has been described as a living hell. On 20th May 2021, even before the ongoing war, Mr. Antonio Guterres, the UN Secretary General, said, I quote, "If there is a hell on earth, it is the lives of children in Gaza," unquote. I stand before the court also in the context of the fast developing circumstances in Rafah, with grave humanitarian implications for the 1.4 million Palestinian people, nearly half of them children. The ongoing war represents one of the most shameful catastrophes in the history of the modern era. The UN agencies and other humanitarian aid organizations on the ground have warned of a humanitarian disaster engulfing the tiny enclave of 2.3 million people, with shortages of food, fuel, drinking water, and medicines worsening by the day. The killing of thousands of innocent civilians, particularly children, the destruction of their homes, the occupation of their ancestral lands, and the deliberate obstruction of the access to food and water all constitute blatant violations of international law and serve as textbook examples of ethnic cleansing. Bangladesh firmly believes that an advisory opinion on the questions posed by the General Assembly would undoubtedly represent a critical and logical step towards ending the illegal occupation. The dismantling of this occupation would, in turn, address the root cause of Israel's violent subjugation of the Palestinian people. We elaborated on these matters and the underlying reasoning in our submissions before the court, Mr. President, on 24 July and 25 October last year. It is pertinent to recall that just 4 months back, the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territories, Francesca Albanese, in her report, brought up several appalling facts. I would consider it apt to quote one pertinent aspect, and I would quote, "In the occupied Palestinian territory, the fundamental right to life is under threat, as indicated by the mortality rates of Palestinian children. The neonatal mortality and infant mortality rates in the occupied Palestinian territory are respectively 9.3 and 12.7 per 1,000 live births, rising to 14.8 per 1,000 live births for children under 5, while in Israel they are 1.7, 2.7, and 3.4 per 1,000 live births. In addition to direct attacks on the right to life, Palestinians also endure structural violence and racial discrimination, which impedes their full development." Unquote. These structural violence of the occupation and the deliberate and excessive use of force against the Palestinians are indeed not limited to the recent events in Gaza. As the Special Rapporteur, Ms. Albanese, stated in her 2023 report, I quote, "The spectre of death looms as a dominant element in the lives of Palestinian children. This reality exerts a psychosocial toll on those who manage to survive, as pointedly expressed by Oadia, a 14-year-old girl. I quote, as she said, "Fearing death does not prevent you from dying, but it prevents you from living." Unquote. Thousands of Oadias keep crying in silence, deprived and disenfranchised for decades. Ending the occupation would necessarily bring an end to the violence that is exercised upon Palestinians on a daily basis. However, there is no end to the occupation in sight, nor is it likely to end through political means alone. It has become interminable. That much was all but confirmed by Israel's Prime Minister, Mr. Benjamin Netanyahu, on 18 January 2024. The court's intervention to us is therefore both timely and necessary. As I proceed with this oral statement, I wish to address whether the occupation of Palestinian territory by Israel is illegal or not. Even though the great majority of states participating in these proceedings, including Bangladesh, are firmly convinced that the occupation is illegal, we note that 2 states contend that it is not. Next, I will state the legal consequences that, in our view, derive from the illegal status of the occupation. On Israel's illegal occupation, Mr. President, members of the court, the fundamental question posed by the UN General Assembly regarding the legality of the Israeli occupation is grounded in established international norms and legal principles. The State of Palestine, in its written statement, underscores the colonial and acquisitive nature of the occupation, emphasizing its deleterious impact on the Palestinian people. The occupation, characterized by persecution, racial discrimination, and apartheid, stands in clear violation of 3 preemptory norms of international law: the right to self-determination, the prohibition of acquiring territory by force, and the prohibition of racial discrimination and apartheid. Numerous submissions have echoed these sentiments, highlighting the temporary nature of belligerent occupation as mandated by international law. The annexation of occupied territory and the settlement of the occupying power's nationals in the occupied area are explicitly prohibited, constituting illegal acquisition of territory under the UN Charter and relevant UN resolutions. Israel's prolonged occupation, coupled with its policies of colonization and annexation, underscores its illegality under international law. These actions not only contravene the UN Charter, but also violate general international law, including the preemptory norm prohibiting the acquisition of territory by force. Furthermore, arguments put forth by states and international organizations reject any justification for Israel's occupation on grounds of self-defense. The occupation violates fundamental principles of international law, including the right to self-determination and the prohibition of acquiring territory by force. The advisory opinion on Wall, which concluded that Israel cannot rely on self-defense to justify its actions, reinforces the notion that the occupation cannot be justified under international law. While the countries supporting Israel in these advisory proceedings have primarily focused on jurisdictional questions, a few states have addressed the merits of the occupation. One contends that an occupation can never be unlawful, regardless of violations of international humanitarian law. However, this argument stands in contravention of established legal principles and has been widely found to be incorrect. Switzerland's distinction between the law of occupation and the legality of occupation further elucidates the legal framework surrounding the issue. An occupation that involves annexation or de facto control of the occupied territory constitutes an illegal acquisition of territory by force as prohibited under international law. Ultimately, Israel's occupation, characterized by its acquisitive, colonial, and annexationist nature, represents a clear violation of international law. It serves as a means for the illegal acquisition of territory and must be brought to an immediate and unconditional end. I may also recall the UN Security Council Resolution 2334 of 23 December 2016, which reaffirmed the obligations of Israel, the occupying power, to abide scrupulously by its legal obligations and responsibilities under the 4th Geneva Convention in regard to the protection of civilian persons in time of war. That Security Council resolution also condemned all measures aimed at altering the demographic composition, character, and status of the Palestinian territory occupied since 1967, including East Jerusalem, including, inter alia, the construction and expansion of settlements, transfer of Israeli settlers, confiscation of land, demolition of homes, and displacement of Palestinian civilians in violation of international humanitarian law and relevant resolutions. Israel has flagrantly violated this and all other Security Council resolutions, and it continues to do so in furtherance of permanently maintaining its illegal occupation of Palestinian territory. At a more granular level, may I refer to the approaches of assessing legality advanced by the former UN Special Rapporteur, Michael Link, in his 2017 report to the UN General Assembly, and the current Special Rapporteur, Francisca Albanese, in her 2022 report. These are apposite and relevant to the Court's task in this case. The two approaches overlap and interrelate, but ultimately provide two pathways for determining the legal status of the occupation. I may humbly request the Court to consider the Link report, where he proposed a four-part test for determining the legality or illegality of an occupation. The Special Rapporteur's approach also fits within the parameters of the Court's advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia. That opinion arose out of Security Council resolution declaring South Africa's continued presence in Namibia illegal. If South Africa's mandate could be found to be illegal due to its violation of the applicable international legal principles, so too can Israel's occupation by reason of its violation of the same principles. Therefore, applying one or both of these frameworks, which Bangladesh endorsed for the reasons stated in our written submissions, we respectfully submit that Israel's occupation is undoubtedly illegal. I would now turn on the legal consequences. Mr. President and members of the Court, there is a broad consensus that Israel, through its denial of the Palestinian people's right to self-determination, has violated preemptory norms of international law. These violations include persecution, racial discrimination, and apartheid against Palestinians, as well as the occupation, colonization, and annexation of Palestinian land. These systematic breaches severely undermine the rights of Palestinians as a people and Palestine as a state, while also hindering the prospects for a just and lasting peace in accordance with international law and relevant UN resolutions. Consequently, international law mandates the complete, unconditional, and immediate cessation of these internationally wrongful acts. All states and international organizations that have condemned Israel's conduct agree that these systematic and grave breaches carry legal consequences for Israel as the responsible state, other states, and the United Nations and other intergovernmental organizations. So, on legal consequences for Israel, first, Israel must cease all acts preventing the exercise of the right to self-determination by the Palestinian people, including rescinding discriminatory laws and measures. This cessation includes withdrawing occupation forces, dismantling illegal structures such as settlements and the wall, and repealing annexation-related legislation. And secondly, Israel must provide reparations for the damages caused and guarantee non-repetition. On the legal consequences of all other states, first, all states must ensure the immediate cessation of any impediment to the exercise of the Palestinian people's right to self-determination and uphold the prohibition of acquiring territory by force and racial discrimination and apartheid. And secondly, states must not recognize the illegal situation resulting from Israel's wrongful acts, including in Jerusalem, and must not provide aid or assistance to maintain this situation. Cooperation is essential to ensure Israel's compliance with international law and humanitarian standards. On legal consequences for the United Nations, first, the UN General Assembly and the Security Council should consider further action to immediately end the Israeli occupation and remove obstacles to Palestinians' rights, including self-determination. And secondly, immediate action is necessary to end the system of apartheid set up by Israel, with relevant UN resolutions implemented without delay. Mr. President, distinguished members of the Court, the promise of a Palestinian state based on a diplomatic settlement grounded in law has been a prominent feature of the international agenda since 1948. 75 years later, there exists a vast body of practice, state practice and opinion jurists that emphatically support the Palestinian people's right to an independent state. The UN Security Council and the General Assembly have adopted numerous resolutions since 1948 on the question of Palestine, recognizing, among other rights, the right of return for Palestinian refugees and the right of Palestinians to establish an independent state along the pre-1967 borders. Additionally, both the UN General Assembly and the Human Rights Council have acknowledged the Palestinian people's right to self-determination. Importantly, in 2004, this court, in its advisory opinion on the wall, explicitly affirmed the Palestinian people's right to self-determination under international law. Bangladesh, drawing on our agonizing struggle for independence, recognizes how the state of Palestine consistently and conclusively reaffirmed her commitment to a peaceful solution. This solution, in accordance with international law and based on the aforementioned terms of reference, aims to ensure the fulfillment of the Palestinian people's inalienable rights under international law. These rights include self-determination, the right of return, the realization of independence and sovereignty of the state along pre-1967 borders, with East Jerusalem as its capital, and the aspiration to live side by side in peace and security with Israel. The Court's steadfast commitment to universally uphold rule of law, coupled with its principled stance on the legality of Israel's half-century temporary occupation of the occupied Palestinian territory, would shine a light of hope on the beleaguered Palestinian people. A decisive determination by the Court of the illegal status of the Israeli occupation of Palestinian territory and the legal consequences that arise from such status, including an immediate, unconditional and complete end to the occupation, would help secure the identity, respect, dignity and existence for the present and future generations of the Palestinian people in a state of their own, at peace with Israel. Mr. President, members of the Court, Palestinians are no expendable people. As much as this advisory opinion involves legal questions, it poses an exceptional moral issues for the humanity. I stand before the Court as Bangladesh deem it our sacred duty to uphold international law as well. On behalf of Bangladesh, I would therefore respectfully request the Court to give full consideration to the importance of an advisory opinion at this critical moment. I'd like to thank you, Mr. President, as well as the distinguished members of the Court for granting Bangladesh this opportunity to participate. Thank you.
I thank the delegation of Bangladesh for its presentation. J'invite la prochaine délégation, la Belgique, à prendre la parole devant la Cour et appelle à la barre M. Piet Herbot. Monsieur, vous avez la parole.
Monsieur le Président, honorables membres de la Cour, c'est un grand honneur pour moi de me présenter devant vous en tant qu'agent du Royaume de Belgique dans cette procédure orale concernant la demande d'avis consultatif qui vous a été soumise par l'Assemblée générale des Nations unies dans sa résolution du 30 décembre 2022. La Belgique est reconnaissante à la Cour de lui avoir donné l'opportunité d'être entendue dans cette procédure consultative. Eu égard au temps qui lui est imparti, la Belgique limitera son intervention à la question de la colonisation et de ses conséquences juridiques. Comme la Belgique a déjà eu l'occasion de le souligner, notamment lors de ses interventions au sein du Conseil de sécurité des Nations unies, c'est une véritable politique de colonisation qui est mise en place par Israël en territoire palestinien occupé depuis des décennies. Cette politique se matérialise par une série de mesures connexes, indissociables à l'établissement des colonies elles-mêmes. Avec votre permission, j'aborderai dans un premier temps le cadre juridique général pertinent pour apprécier la question de la colonisation en territoire palestinien occupé. Dans un deuxième temps, je m'attarderai sur le caractère illicite de l'établissement des colonies. Le professeur Vaios Koutroulis se penchera ensuite sur les règles pertinentes pour apprécier l'illicéité de la politique de la colonisation du territoire palestinien occupé et des mesures connexes adoptées par Israël dans ce cadre. Il terminera en exposant brièvement les conséquences juridiques des violations du droit international qui auront été identifiées. Monsieur le Président, la Belgique commencera son exposé par un bref rappel du cadre juridique pertinent pour apprécier la question de la colonisation. La politique de colonisation d'Israël s'inscrit dans le contexte général de l'occupation prolongée du territoire palestinien. Dans son avis consultatif du 9 juillet 2004 sur les conséquences juridiques de l'édification d'un mur dans le territoire palestinien occupé, la Cour a fourni les clarifications suivantes quant au cadre juridique général de l'occupation en question. Premièrement, le territoire palestinien contrôlé par Israël depuis 1967, y compris Jérusalem-Est, est un territoire occupé. Deuxièmement, l'illicéité de l'acquisition de territoires par la force s'applique au territoire palestinien occupé. Cette règle interdit l'annexion du territoire par Israël, y compris une annexion de facto. Troisièmement, l'article 51 de la Charte des Nations unies est sans pertinence au cas particulier, puisqu'il s'agit d'un territoire occupé par Israël. Quatrièmement, le peuple palestinien bénéficie du droit à l'autodétermination. Cinquièmement, les instruments relatifs à la protection des droits humains s'appliquent de manière extraterritoriale, y compris en situation de conflit armé et d'occupation militaire. Il ressort de ce qui précède que tout territoire au-delà des frontières de 1967, effectivement contrôlé par Israël, est un territoire occupé et que toute annexion de tout ou partie du territoire en question, que ce soit de jure ou de facto, est interdite en droit international. Ainsi, sont applicables en territoire palestinien occupé les règles conventionnelles et coutumières du droit international humanitaire, notamment celles énoncées dans le règlement annexé à la 4e Convention de La Haye de 1907, ainsi que l'ensemble des règles de la 4e Convention de Genève de 1949. Sont également applicables le droit à l'autodétermination et les règles relatives à la protection des droits humains. En situation d'occupation prolongée, les droits humains ont une importance particulière pour la protection de la population occupée. À cet égard, il doit être noté que le terme occupation prolongée ne correspond pas à une catégorie juridique spécifique qui serait régie par des règles différentes. En d'autres termes, les mêmes règles s'appliquent à toutes les occupations, qu'elles soient prolongées ou pas. Le caractère prolongé d'une occupation a un effet non pas sur l'applicabilité des règles, mais sur leur application. Ainsi, par exemple, plus l'occupation dure, plus il deviendra difficile d'invoquer les exceptions liées à la nécessité militaire de la puissance occupante qui sont prévues dans certaines règles du droit international humanitaire, ou les dérogations liées à la nécessité prévue dans les instruments de protection des droits humains. De même, plus l'occupation dure, plus les obligations positives de la puissance occupante s'interpréteront de manière large. Ces obligations étant des obligations de comportement, les États doivent mettre en œuvre tous les moyens qui sont raisonnablement à leur disposition pour les réaliser. Dans une situation d'occupation prolongée, le contrôle établi implique que la puissance occupante a plus de moyens à sa disposition pour réaliser les obligations positives issues du droit international humanitaire et des droits humains. Après cette brève présentation du cadre juridique général, je m'attacherai maintenant au caractère illicite de l'établissement des colonies en territoire palestinien occupé. L'article 49, alinéa 6 de la 4e Convention de Genève de 1949 prévoit que, je cite, « La puissance occupante ne pourra procéder à la déportation ou au transfert d'une partie de sa propre population civile dans le territoire occupé par elle. » Fin des citations. Dans son avis consultatif de 2004, votre Cour a conclu que, je cite, « Israël a mené une politique et développé des pratiques consistant à établir des colonies de peuplement dans le territoire palestinien occupé, contrairement aux prescriptions du 6e alinéa de l'article 49. » Fin de citation. Conformément à cette conclusion de la Cour, la Belgique a affirmé le caractère illicite de l'établissement des colonies en territoire palestinien occupé au regard de la 4e Convention de Genève. En outre, la Belgique considère que l'établissement des colonies est contraire aux résolutions pertinentes du Conseil de sécurité, dont je ne citerai, faute de temps, que la résolution 2334 adoptée le 23 décembre 2016. Conformément aux critères énoncés par votre Cour dans l'avis consultatif sur la Namibie, cette résolution constitue une décision énonçant des obligations à destination des États membres des Nations unies. Ainsi, après avoir affirmé que la création des colonies constitue une violation flagrante du droit international, le Conseil de sécurité, je cite, exige de nouveau d'Israël qu'il arrête immédiatement et complètement toutes ses activités de peuplement dans le territoire palestinien occupé, y compris Jérusalem-Est. Fin de citation. Au vu des termes clairs du paragraphe mentionné, il est évident que la poursuite de la politique de colonisation par Israël contrevient à la résolution 2334 du Conseil de sécurité. Ceci conclut le deuxième point de l'exposé oral de la Belgique. Monsieur le Président, avec votre permission, je vais maintenant passer la parole au professeur Vaios Kotroulis pour poursuivre la présentation des arguments de la Belgique. Je vous remercie pour votre attention.
Je remercie Monsieur Herbot. Je donne à présent la parole à Monsieur le professeur Vaios Kotroulis. Monsieur, je vous en prie.
Monsieur le Président, honorables membres de la Cour, c'est un immense honneur pour moi de me présenter pour la première fois devant vous aujourd'hui au nom du Royaume de Belgique. Je poursuivrai l'exposé oral de la Belgique en me penchant sur les règles pertinentes pour apprécier l'illicéité de la politique de la colonisation du territoire palestinien occupé, avant de conclure sur les conséquences juridiques des violations identifiées. Le Conseil de sécurité, dans sa résolution 2334 de 2016, met clairement en exergue le caractère multidimensionnel de la politique de la colonisation du territoire palestinien occupé. Dans le même ordre d'idées, la Belgique a insisté dans ses interventions au sein du Conseil de sécurité sur les liens entre l'établissement des colonies et ces mesures connexes, mesures qui font partie intégrante d'une véritable politique de colonisation illégale. Il est ainsi impossible d'analyser juridiquement cette politique de colonisation sans avoir égard aux mesures concrètes par lesquelles elle se matérialise, au contexte général dans lequel elle s'inscrit et aux effets produits par elle. Les mesures par lesquelles la politique de colonisation se matérialise, considérées individuellement, sont problématiques à l'égard du droit applicable en territoire occupé, à savoir notamment le droit international humanitaire et les droits humains. À cet égard, la Belgique a toujours condamné tout particulièrement le recours à la violence par les colons envers la population palestinienne occupée et souhaite relever l'obligation d'Israël de mettre fin à cette violence et d'en punir les auteurs. Mais plus fondamentalement, la politique de colonisation vise à obtenir une modification de la composition démographique du territoire palestinien occupé et du statut du territoire lui-même. À ce titre, cette politique est contraire à plusieurs règles fondamentales du droit international. J'aborderai successivement l'interdiction de l'acquisition du territoire par la force, le droit à l'autodétermination et le principe de non-discrimination. Premièrement, la politique de colonisation est contraire à l'interdiction de l'acquisition du territoire par la force. Cette interdiction fait partie intégrante de l'interdiction du recours à la force, énoncée dans l'article 2, paragraphe 4 de la Charte des Nations Unies, dans la résolution 2625 de l'Assemblée générale des Nations Unies, ainsi que dans l'article 3, alinéa A, de la définition annexée à la résolution 3314 de l'Assemblée générale. Dans son avis consultatif de 2004, votre Cour a confirmé l'applicabilité de l'interdiction de l'acquisition du territoire par la force au territoire palestinien occupé. Cette interdiction comprend l'annexion tant de jure que de facto. Les mesures adoptées par Israël dans le cadre de sa politique de colonisation visent à la création sur le terrain d'effets irréversibles et la consolidation de son contrôle sur le territoire concerné à travers l'établissement des colonies. Elle crée ainsi une situation de fait accompli qui s'apparente à une annexion de facto, telle que votre Cour l'a définie dans son avis consultatif de 2004. Deuxièmement, la politique de colonisation est contraire au droit à l'autodétermination du peuple palestinien. Ce droit est consacré dans la Charte des Nations Unies et réaffirmé dans la résolution 2625 de l'Assemblée générale, ainsi que dans l'article 1er du Pacte international relatif aux droits civils et politiques et du Pacte international relatif aux droits économiques, sociaux et culturels de 1966, pacte auquel Israël est partie. La résolution 2625 précise que le fait de soumettre des peuples à la subjugation, à la domination ou à l'exploitation étrangère constitue une violation du droit à l'autodétermination et que les États ont le devoir de s'abstenir de recourir à toute mesure de coercition qui priverait les peuples de leur droit à l'autodétermination. Dans son avis consultatif de 2004, votre Cour a conclu à la violation du droit à l'autodétermination. Pour ce faire, elle a porté une attention particulière aux mesures entraînant le départ des populations palestiniennes de certaines zones et la modification de la composition démographique du territoire palestinien occupé. De même, dans son rapport publié le 14 septembre 2022, la Commission internationale indépendante créée par le Conseil des droits de l'homme est chargée d'enquêter dans le territoire palestinien occupé, y compris Jérusalem-Est et en Israël, souligne que, je cite, le choix de l'emplacement de certaines nouvelles colonies réduit encore la probabilité de la fin de l'occupation et viole le droit des Palestiniens à l'autodétermination. Fin de citation. Il ressort de ce qui précède que l'adoption de mesures coercitives liées à la politique de colonisation visant à la modification du statut et de la composition démographique du territoire palestinien occupé est contraire au droit à l'autodétermination. Troisièmement, la politique de colonisation suscite de sérieuses inquiétudes au regard du principe de non-discrimination. En effet, l'établissement des colonies est intrinsèquement lié à la mise en place de deux systèmes institutionnels et juridiques distincts, l'un pour les habitants des colonies et l'autre pour la population palestinienne du territoire occupé. La Commission internationale indépendante chargée d'enquêter dans le territoire palestinien occupé, y compris Jérusalem-Est et en Israël, ainsi que le Comité pour l'élimination de la discrimination raciale ont souligné justement le caractère problématique des mesures concernées par rapport au principe de non-discrimination. Ainsi, et pour conclure avec cette partie de l'exposé oral du Royaume de Belgique, la politique de colonisation est problématique à l'égard de l'interdiction de l'acquisition du territoire par la force, du droit à l'autodétermination et du principe de non-discrimination. J'en viens à présent au quatrième et dernier point de l'exposé oral de la Belgique, les conséquences juridiques des violations identifiées. Je commencerai par les conséquences juridiques pour Israël, avant de m'attarder sur les conséquences juridiques pour les États tiers et les organisations internationales. À titre liminaire, la Belgique souhaite souligner le fait que plusieurs règles mentionnées ci-avant sont des normes impératives du droit international général. On pense par exemple au droit à l'autodétermination et à l'interdiction du recours à la force, dont fait partie l'interdiction de l'occupation et de l'annexion d'un territoire par la force. De ce fait, aucune circonstance excluant l'illicéité ne peut être invoquée pour justifier leur violation. Pour Israël, les violations identifiées entraînent les conséquences prévues par les règles coutumières de la responsabilité internationale, codifiées dans les articles sur la responsabilité internationale des États pour faits internationalement illicites, adoptés par la Commission du droit international en 2001. Il s'agit de l'obligation de mettre fin à une violation continue, l'obligation de réparation, ainsi que l'obligation d'offrir des assurances et des garanties de non-répétition. Concrètement, concernant la politique de colonisation, eu égard au caractère continu de la violation, la Belgique se permet de mettre en avant tout particulièrement l'obligation d'Israël de mettre fin à toute activité de colonisation. Comme il a été affirmé dans le cadre de l'avis consultatif de 2004, l'obligation des réparations doit tout d'abord prendre la forme d'une restitution, à savoir, entre autres, le démantèlement des colonies de peuplement, l'annulation des actes juridiques liés à la politique de colonisation et la restitution des biens réquisitionnés ou expropriés dans la mise en place de cette politique. Celle-ci est également l'option privilégiée par la résolution 2334 de 2016 du Conseil de sécurité. Concernant les États tiers, leurs obligations sont fondées sur plusieurs règles du droit international, à savoir les règles relatives à la responsabilité internationale des États, l'obligation de faire respecter le droit international humanitaire, ainsi que le droit à l'autodétermination. Dans un premier temps, pour ce qui est des violations graves des normes impératives du droit international, les États ne doivent pas reconnaître comme licite une situation créée par une violation grave d'une norme impérative, ne doivent pas prêter aide ou assistance au maintien de la situation illicite créée par la violation grave de la norme impérative et doivent coopérer pour mettre fin à la violation. Dans un deuxième temps, pour ce qui est des violations des règles du droit international humanitaire, l'obligation conventionnelle et coutumière de faire respecter ces règles est énoncée dans l'article 1er commun aux 4 conventions de Genève. Cette obligation s'adresse aussi aux États tiers et comprend des obligations tant négatives que positives. L'obligation de ne pas encourager, ne pas aider ou ne pas assister à la commission d'une violation constitue un exemple d'obligation négative. L'obligation d'adopter des mesures pour inciter les parties belligérantes à cesser les violations du droit international humanitaire est un exemple d'obligation positive. Dans un troisième temps, une obligation similaire envers les États tiers existe en ce qui concerne le droit à l'autodétermination. En effet, la résolution 2625 prévoit que, je cite, « Tout État a le devoir de favoriser, conjointement avec d'autres États ou séparément, la réalisation du principe de l'égalité des droits des peuples et de leur droit à disposer d'eux-mêmes. » Fin de citation. La résolution 2334 de 2016 fournit un exemple concret des mises en œuvre de toutes ces obligations. Dans cette résolution, le Conseil de sécurité demande à tous les États de faire une distinction dans leurs échanges en la matière entre le territoire d'Israël et les territoires occupés depuis 1967. Cette demande reflète l'obligation de mener ces relations, y compris les relations économiques et commerciales, de telle manière à ce qu'aucune reconnaissance, aucune assistance et aucune contribution ne soit fournie au maintien de la situation illicite des colonies. Enfin, et ceci sera le dernier point soulevé par le Royaume de Belgique, les conséquences juridiques liées aux violations graves des normes impératives sont également valables pour les organisations internationales. Une organisation internationale agira évidemment dans les limites de son mandat. Mais lorsqu'elle a un pouvoir discrétionnaire d'agir, elle doit exercer ce pouvoir de sorte à mettre fin aux violations graves des normes impératives. Monsieur le Président, Mesdames et Messieurs les membres de la Cour, ceci conclut l'exposé oral du Royaume de Belgique. Je vous remercie pour votre aimable attention.
Je remercie la délégation de la Belgique pour son exposé qui met un terme à l'audience de ce matin. La Cour se réunira de nouveau cet après-midi à 15 h pour entendre le Belize, la Bolivie, le Brésil et le Chili. L'audience est levée.